What if the real owner of a company is hiding behind layers of companies, trusts, and entities? Who actually controls the business? Who pulls the strings? That's where Section 90 steps in to reveal the ultimate controller. Welcome to Corporate and Securities Law Compass. I'm Mr. Prashad Khopkar. Today, we decode a powerful anti abuse provision, Section 90, Significant Beneficial Owners, SBO. Let's break it into provision explanation, practical examples. Under Section 90 of the Companies Act 2013, who is an SBO? An individual who holds 10% or more beneficial interest or exercises significant influence or control, even indirectly, through companies, trusts, partnerships. Declaration by SBO must disclose ownership form. BEN 1. Company's duties. Serious. Maintain register of SBO form BEN 3. File return with ROC form BEN 2 within 30 days. Register must be open for inspection, minimum 2 hours daily. Company must actively identify SBO, not passive compliance. Must investigate ownership layers. Notice mechanism. If company suspects SBO, issue notice BEN 4, serious. Reply within 30 days. Non-compliance. Individual penalty 50,000 rupees plus 1,000 rupees per day. Stern. Company penalty 1 lakh rupees plus 500 rupees per day. Strongest weapon. Tribunal power. If no disclosure, company can approach NCLT. Consequences: freeze shares, stop voting rights, restrict transfer. False information treated as fraud. Section 447 applies. False information treated as fraud. Section 447 applies. Now let's simplify this powerful concept. What is SBO? It is the real person controlling the company, even if hidden behind layers. Example structure: Company A, Company B, individual X. X is the actual controller, SBO. Why Section 90 exists? To prevent shell companies, money laundering, hidden ownership. It ensures transparency, accountability, true control, identification. Difference from Section 89. Section 89, any beneficial owner. Section 90, significant plus controlling owner, 10% plus. Indirect holding concept. Even if shares are not directly held, through holding companies, through trusts, through LLPs. Law tracks the real individual. Company's role is active. Investigate issue notices, identify SBOs. Tribunal power is very strong. Freeze ownership rights, suspend voting, block transfers. Example 1. Mr. Prasad Khopkar, Direct SBO. He holds 15% shares. He is SBO, files BEN 1. Company records BEN 3, files BEN 2. Example 2. Indirect holding. Mr. Khopkar owns 60% in Company X. Company X owns 20% in ABC Limited. Indirect equal to 12%. He becomes SBO. Example 3. Through trust. Shares held via trust, beneficiary controls benefits. Beneficiary equal to SBO. Example 4. Non-disclosure. SBO hides identity. Company issues BEN 4, no reply. Goes to NCLT, shares frozen. Example 5. Acting together. Family members hold small percentage individually. Combined control greater to 10%. They qualify as SBO. Example 6. Complex layering. Foreign entity, Indian company, individual. Individual identified as SBO. Disclosure mandatory. Summary. Section 90 ensures identification of real controllers, transparency in ownership, strong enforcement system, corporate accountability. Section 90 pierces the corporate veil to reveal the true controller. For more powerful breakdowns of corporate law, like, share, subscribe. This is Corporate and Securities Law Compass. See you in the next concept. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, or any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.